We have been talking about cross-border data transfer for quite some time now. Now, today we will discuss the legal and regulatory requirements of conducting the data transfer impact assessment, typically conducted before you decide to transfer your information, personal information, outside European country. There are laws and regulations for other countries as well, but primarily it came out of GDPR, and in this video we are going to talk about not only GDPR but other countries also. Welcome to my YouTube channel where you have been daily watching new content on data privacy. As I mentioned, we are going to talk about the legal requirements of conducting a data transfer impact assessment, which practically means that when you are going to move your personal information out of a European country to a non-European country, you need to check whether that country is adequate enough or not. By definition, adequacy of a country under GDPR means that the country is adopting adequate laws and safeguards towards personal information, both in terms of collecting, storing and protecting personal information. So when personal information of a European citizen goes out of Europe, as per GDPR, they need to check whether that country is adequate enough or not. And this DTIA then therefore helps them regulate, follow the GDPR norms, comply with GDPR norms, and have safe cross-border data transfers, protecting the data subjects or the users' personal rights. So when it comes to GDPR Article 44 to 49 are dedicated towards DTIA. What do they say? Article 44 says that whenever you are moving data out of the European Union, it should meet conditions and safeguards for protecting the data subject rights and interests. Article 45 further says that the first thing that you should do is you should recognize whether that non-European country is adequate enough or not. That means whether they follow adequate data privacy norms or not. Article 46 says that if in case they don't, then you need to follow the concept of SCCs, BCRs and approved code of conduct. We have already seen SCCs are the standard contractual clauses and BCRs are the binding corporate rules, right? So either of these need to be followed if you find that the destination country is not adequate, that is, they don't have their own proper laws, framework on data protection and privacy. Article 49 allows derogations, that means violations to DTIA, or allows cross-border data transfer even to inadequate or non-adequate countries only if the transfer of information is required to help get better performance out of the project or the contract, or if there is an explicit consent from the data subject that his personal information would be moved out of the European country to a non-adequate country. Shrums to another set of rules in GDPR. It says that you need to perform DTIA even if you are using a standard contractual clause. So standard contractual clause is a matter of documentation in contracts. You should still conduct a DTIA even if you are following the standard clauses. The next regulation that we are going to briefly touch upon is CCPA, the Californian Consumer Privacy Act. There is no specific restriction or provision of monitoring or safeguarding the personal information moving out of California. They say that the data transfer should be compliant. It should follow the Californian privacy law applicable for information within California, and the same should apply for information that moves out of California. Businesses should conduct assessments to see that the movement of information out of California is safe. LGPD, or the Brazilians, they follow GDPR, so their regulations are similar to GDPR. They say that you transfer only if adequate protection is available at the destination, and you should use contractual clauses and DTIA, that is Data Transfer Impact Assessment, to verify the adequacy of protections. The smaller countries like Singapore and Canada also have regulations around the DTIA. Their regulations say that the data transfer must always be protected. They should follow, that is the destination country or the companies which are moving the data out of Singapore or Canada to any other country should follow the data transfer and the data protection privacy norms laid down within Singapore or Canada respectively. DTIAs should be used to ensure adequacy of the foreign laws, and the organization should use DTIA to ensure that there are appropriate measures in place in moving the data out of Singapore and Canada. We talked about this yesterday also. We talk about touching base on this again. How does data transfer impact assessment helps? It helps you comply with the data protection laws, mitigate the risk of personal information of your data subjects, enhance your business reputation, give that confidence to your data subject that their information is safe, even if going to a non-adequate country, and create a legal accountability both of your own data subjects, your own company, as well as the legal accountability of the company where the data is being transferred in the destination country or a non-adequate country. That's what is about the legal and regulatory requirements of conducting a DTIA. I hope you like my content. Please press the bell icon and the like button. Subscribe to my YouTube channel and share your feedback in the comment section. Thank you.